Okay, today is Monday, April the 11th, and it's 2022, and it's about 7:02 p.m. And welcome to week number week two of your constitutional law. And I'm Professor Richard Wright. Today I'm wearing my lawyer t-shirt that was a gift to me. So I'm going to go ahead and start talking about the requirements for this week's assignment. Let me get to setting up something first. Give me 1 minute. Here we go. Okay, so we're gonna go ahead and let me share my screen with you. I see Mindy is there. Hello. And here we go with setting this up. Okay. Okay, guys, as you can see, this is the page that tells you that you're in the right class, constitutional law. And, we have messages. I'm not going to click on them today. Your grade book, which basically shows you where you find your grades. I have 17 assignments to grade for week one. By the way, those grades will be completed by Friday or before. I've already completed discussion posts. And I will today go back and make sure that those who have not turned in their assignments for week one will have zeros next to their name. Of course, the zeros are not final grades. You should be aware of that. And that those zeros, just a reminder that you haven't turned in the assignment. Remember, you have 10% loss for each day, unless there was extenuating circumstances. To my knowledge, no one in this class has had extenuating circumstances, at least for week one. Okay, so let's take a look at our calendar. Move that over. And you can see where we are now. We are at the 11th, where we have our live lecture now. Initial posts due tomorrow night. Reply posts due Saturday. Your live classroom word or phrase is due Sunday the 17th. And then your written assignment is due. Okay. And then, of course, as I will do every week, I will show you when the course ends, and that will be the 10th of this month. Okay. And so that's not far off. That's less than a month from now. Today is the 11th. So it was 30 days from yesterday. So the term will be over pretty fast. So keep up with those assignments. Absolutely all assignments must be in by the 10th, unless you've gotten an incomplete based on what I talked about in week one. Week one's lecture is longer, but it's always important, if you have any questions about something that you want to know, that you listen to that again, because I will not be repetitious in a lot of the things that I went over in there, especially letting you know about certain benefits that you have in terms of helping you. I do remind you, though, that if you want to text me, call me, or email me any hour of the day except the 25th hour of the day, that is acceptable. And the phone number is 630-660-8480. That is found in the lounge area at the chat at the bottom, where you'll see my picture of my family and myself, and some information about me, and you also can find it on the syllabus. That is always a place that you can find it as well, in case you forget it. But do reach out to me if you have a problem. I say it all the time. I remind my students. Okay, that's that. Let's take a quick look at the announcements. Okay, so our week 2 announcement, here it is. We're going to deal with the 14th Amendment and the exclusionary rule. You had to read chapter 7 of the textbook. I provided you with the PowerPoints. And we're going to talk about teaching the forgotten 14th Amendment and the Constitution of Memory, the exclusionary rule, 14th Amendment, research starter, exclusionary research starter. So you'll talk quite a bit about the exclusionary rule today and the 14th Amendment. And we'll explain how all of that works. There's a knowledge check that you also can take yourself, but I will show it to you anyway. Remind you that the lecture is taking place right now, 7:00 p.m. on Monday. Discussion assignment, the exclusionary rule, which is due again on Sunday at 11:59 p.m. Central Standard Time. I'm sorry, the exclusionary rule is a discussion assignment that's due Tuesday and Saturday, 11:59 p.m. But I was right about what I said a few minutes ago, is that the written assignment, which is due Sunday, the 17th, the Supreme Court and the exclusionary rule. And of course, that is due this Sunday. And be sure you pay close attention to the module, what I say in the lectures, and the rubrics. That's the key to keeping you with good grades. And so I remind you to continue to be strong and to finish strong. And my motto, adversity is springboard to success. I shared that with you last week in the announcement that is still right there. If you click on it, you can take time to look at that. Okay, so now you've seen at least 2 places where you know your due dates and you know what your assignments are. So now let's go to, yeah, I didn't mean to do that. Let's get out of that. Close it. And let's close that. Okay. Let's get to 2. Okay. And let's go over the written assignment. So here's the written assignment for this week. Again, reminding you it is due this Sunday. So we're dealing with procedural due process about what we call fundamental fairness and how the legal procedures are followed, that when law enforcement officers are exercising their duties and authority, that they have to keep in mind the exclusionary rule, which we will be talking about quite a bit today, and that it is a tool that is critical in keeping law enforcement in check. In other words, guaranteeing that the law enforcement, when they conduct their arrests, their searches, they will be doing so consistent with the rights of defendants and all individuals, citizens of the United States of America. And so we're going to have you to look at 2 U.S. Supreme Court cases, and they're listed here, so you don't have to go looking for them, and discuss how the exclusionary rule was applied in these cases. And these 2 cases are Hudson versus Michigan. I'm not going to go over them, but be sure that when you do use those cases, for example, I'll show you under Hudson versus Michigan, it does list Oyez, but I don't want you to use that citation. I want you to use the official citation for the case. And this tells you a little bit about the court at that particular time. But do not cite Oyes as a source or Justia. I want you to cite the official court case, which you'll see it in just a few minutes. Usually, I wish they would put it in here, but I will make sure that you do have it. And then Missouri versus McNeely. So you're going to enter 3 to 5 page paper. That's double space, APA formatted. Okay, we've discussed what APA means. Of course, citations in the body, reference in the end, and it also means a cover page, Roman 12 font. But if you have issues about that, use your APA resources to make sure that you're doing it. So you're going to summarize the facts of each case. I did not say copy and paste. I said summarize the facts. Explain how the exclusionary rule is applied in the case. Identify how any exceptions to the exclusionary rule may have applied to either case. I didn't say they will, but may. We'll talk about some exceptions. And I'm going to provide you with remind you that credible sources included with the reference page, spelling and grammar. I'm going to provide you with some material that I have that helps you with the issue of the exclusionary rule, and you'll receive that as well. Resources we already talked about these resources as well. Let's look at the rubric real quick. Remember, you don't want to be in this column. You really don't. 50% is not passing. By not providing credible sources, you supply incomplete summary or incorrect. You've got to have credible sources. That's what I explain to all of my students. You automatically go from here to here if you have no credible sources. And then it reminds you here as well. And you have to satisfy the 3-page requirement, not 2.5, but full 3 pages, and no errors. Remember, you're getting ready to get your bachelor's. You want to make sure you do that. So let's look over here at the summary of Hudson versus Michigan. And so you're going to provide everything in this column. Make sure that I know you understand the case. Same thing with Missouri versus McNeely. The exclusionary rule. Outstanding explanation of the rule and how it applies. Outstanding identification of how many exceptions may be applied in either case. And of course, if you don't think there are any, explain away and provide the reasons why. Remember, support your statements. Credible sources are cited, APA format, we already talked about that, and then here. So you want to get in this column. This is where you want to be. Okay. Any questions? Type yes if you have any in the chat box, or no. Or if I don't see anything, I'll just presume that you're all good with it. There's 5, 4, 3, 2, 1, none. Okay, I don't see anything in the chat. Let me just open up the chat so I'll have it handy. Nope, I don't see any. All right, so I'm going to close that back down. It'll pop up if it does. Provide any questions. Now, one of the things that I want to do is this, and I want to make sure that you you have what I am talking about. Give me 1 second. I have it here in my notes here. Let me pull it up. Okay. 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 The appropriate citation for Hudson versus Michigan is 547 US 586, and in parentheses 2006. 2006. Okay, so I'll repeat it. It's 547 US 586, and in parentheses the year 2006. Okay, that's how I want you to cite that case. I want you to cite all cases that way as well. Okay, now I want to give you Missouri versus Neely. Give me 1 second. Let me pull it up on my notes here. I keep on my little phone here. Okay, here we go. Okay, Missouri versus McNeely is a 2013 case, and it is cited as Missouri versus McNeely, 569 US 141. 569 US 141, and in parentheses 2013. So you have that. All right. And it's very important that you cite the case. Now, somebody's going to say, well, I didn't see it anywhere. I said, you didn't listen to the lecture then, because I gave it. So very important to use it. Now, you don't have to use it over and over and over in the paper. You know how to do it APA. You start out with it. And I'm not talking about at the caption at the top. I'm talking about in the body of the paper. But then you appropriately cite it after that. Okay. So that's it on the written assignment. All right, let's get that in here. Let's go to the next thing, which is the discussion. So the exclusionary rule. I won't tell you why I'm smiling, but you'll find out a little later. You're going to discuss the exclusionary rule and apply it to a real world scenario. So you're going to have this scenario here. This is a this is one of my favorite discussion posts. This is my favorite one in this course. So I like to read it. You are a homicide detective. You and another detective are interviewing a homicide suspect. His name is John Smith. At his residence, John invited you into the house, and the interview takes place in the front living room next to the front door. You ask and receive permission from John to use his bathroom. John tells you to walk through the kitchen and down the hallway to the bathroom. Okay? For whatever reason, you take and exercise a habit of routinely opening a refrigerator and freezer doors and looking inside. That's being nosy. In this instance, when you open the freezer door, you are startled by the presence of a severed head, which is inside a plastic bag. There's a human head, okay? You yell to your partner, get him. John puts up a fight, but is eventually taken into custody. The severed head is later positively identified as a recent homicide victim. Now, you're going to, in your initial post, explain the exclusionary rule, which, you know, discuss if the rule applies to this scenario. Justify your answer. If the exclusionary rule applies, what are the potential ramifications if the rule does apply. What does that mean? Support your commitment with a sound legal argument. This is so interesting. Reply to at least one other post uh, and respond to one of your colleagues and discuss if you support your peers' discussion, and if so, why, and if you disagree, explain why. Again, um, I'm not even going to scroll down to responses because I already see two already, and I'm not going to do that. Um, remember, this is a post first, which means that you can't see the posts of individuals until you have posted yours initially. But this is it's basic to me, uh, and stop and think about it once you understand the exclusionary rule. Okay, and all the facts are in here to help you reach that conclusion. Okay, your live classroom submission, of course, you know what you do here. You click and put it in here, and you will be able to get your credit for it. And then, of course, this is the link that will be changed after this, and I will take this out and include the link from YouTube, as well as I will email it to you so that you will have, even if you're here, you still would maybe want to have it. Okay, so let's talk about the 14th Amendment, the exclusionary rule, exceptions to the exclusionary rule, and then we're going to do the knowledge check. Okay, so let's talk about the 14th Amendment. As you should be aware, that the Constitution of the United States has the first 10 amendments, which are called the Bill of Rights. Okay, and the ones that we are most familiar with and applying in criminal cases, as I've said, is a little bit of the first, some of the second. The First Amendment is freedom of speech, the press, but we deal with the speech aspects of it. And then we, Second Amendment, the volatile Second Amendment of the Constitution that has to do with the right to bear arms. And then we deal with, for most of that, which includes today, the Fourth Amendment, which deals with unreasonable search and seizures, and makes it quite clear about unreasonable search and seizures. All right, we'll talk about that more in detail. And then the Fifth Amendment, the right to self-incrimination, we won't be dealing too much with that today. The Sixth Amendment, right to a speedy trial. And of course, in the Sixth Amendment, also the very important right to counsel that was established by Gideon versus Wainwright. One of the leading cases, by the way, going back to the Fifth, is of course Miranda versus Arizona. Okay, the good old Miranda warning case. And then the Eighth Amendment, which deals with punishment and the death penalty and cruel and unusual punishment. Okay, now be aware that originally when the Constitution was written, those things that I mentioned, those amendments applied to the federal government, to federal cases. Okay, now, but in 1868, after the Civil War and the Reconstruction era to establish Black American civil and legal rights, the first section, that's the one we primarily will deal with, is cited in due process cases, which means that you have a right to evidence, things that we talked about last week, the right to evidence, the right to cross-examine, the right to the information that the prosecution has in a criminal case against you. And so these other sections, I will just touch on them, but I won't spend much time. So I'm just going to read 14th Amendment, Section 1. All persons, born or naturalized, and subject to the jurisdiction, are citizens of the United States and of the state in which they reside, okay, where their residency. No state shall make or enforce any law that shall abridge the privileges or immunities of the citizen of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. I just got through describing that. Nor deny any person within its jurisdiction of equal protection of the laws, which brings the understanding that all people should be treated the same and you should be treated fairly. And that's what that is. Okay. Section 2. So that's the one that you want to focus on, guys. Understanding how that works. And we're going to spend more time implementing that into what we talk about in just a few minutes. Section 2 is a little bit of historical stuff that deals with voting rights, and at that time it was males over 21 years of age, regardless of race. Women's votes not until the 19th Amendment, which came in the 20s. Section 3 deals with holding office. Section 3, yeah, deals with not only holding office, but the intent to prohibit Confederate leaders from obtaining office after they receive presidential pardon. So 4 to deal with slaveholders denied payment for the loss of human property because slaves were freed. And then Section 5 with the authority to enforce the provisions. And this was the law that the foundation for the Civil Rights Act of '64, prohibiting discrimination on the basis of race, religion, sex, or national origin is involved. Also, some parts of this was involved in the other Civil Rights Act that came about. And you're dealing with the citizens' rights. We already described what those were. The privileges and immunities. And you know, you can request the right to redress the grievances, the right to vote, the right to enter public lands, and the right to be protected from violence when in custody of a U.S. Marshal, and so forth. And the list goes on and on and on. Due process clause. Again, I kind of explained that already, but it is quite clear that this section forbids the states, remember what I said, the states, from depriving individuals of the right to procedural due process. It just gives a little history here. All right. So you have rights that, like the Fifth Amendment clause, as well as the First Amendment, as well as the other amendments that I mentioned. But notice what it says here, reiterating what I said. It was not until the 14th Amendment was passed that required equal protection of the law and due process for all citizens that began to employ selective enforcement of amendment provisions. The states themselves had to do that. Fundamental fairness. Fundamental fairness. The requirement that says legal procedures are followed in every state, even in Louisiana. Why did I say that? The reason why is because all the other jurisdictions, the law is based upon English law, derived from Britain, Great Britain or England. But Napoleonic Code is what operates in Louisiana, and it's French based, but they're still held subject to the United States Constitution. So the state, as it says, typically complies with the fundamental fairness when an accused is provided with the notice of charges against him. I previously stated, opportunity for hearings, confrontation, and cross-examining, discovery of evidence, basis of any decision, and the availability of counsel. That, we talked about Sixth Amendment there. Okay, so be aware, the 14th Amendment is what we hang our hats on to trigger that. Excuse me. One of the most interesting things that I have to drum into my students' head is that prior to the 14th Amendment, none of the constitutional amendments applied to the states. It was just the federal government. But that's an interesting principle. I couldn't imagine operating where you had to have a federal case in order to have your constitutional rights. I mean, that would mean that the Fourth Amendment search and seizure stuff would be violated by the states, the Fifth Amendment to self-incrimination, the Sixth Amendment right to counsel, speedy trial, the Eighth Amendment, cruel and unusual punishment, and death penalty, and those things. That I couldn't imagine that. So now let's talk about a tool that I was very adept at as a criminal defense lawyer. It's one of our great tools that we utilize in our defense of individuals. And before I get into it, it is often thought by law enforcement people that it's unfair. And I have often said to many of them who I had law enforcement individuals as criminal clients that you wait until it's your turn to be in that position. You can ask like people like Derek Chauvin, you can ask those other police officers, Kim Potter, just to name a few contemporary cases that we're familiar with, that they want the exclusionary rule in there because you can't really provide an adequate defense in state court without it. And so it's not trickery. But remember, as I teach you guys constantly about your assignments, following the process, making sure that you pay attention to the rubrics and to the modules and what I say in the lecture, that's going to carry over into your existence, whether you're in law enforcement, probation, parole, corrections, whatever area that you're operating in. And if you don't follow the processes appropriately, the exclusionary rule will come back and bite you. So let's talk about it. All right, as you can see, this is a familiar picture. And so you are a law enforcement officer, and you find yourself placing a person under arrest. Okay, like it uses this tipster report that this guy's selling cocaine from his house and gives his address. You suspected that David had been selling cocaine but not able to prove it. However, you believe that the anonymous tip is what you need to finally search David's house. So the next day, you and a couple other officers knock on David's door. He answers, refuses to consent to search. Okay? With the anonymous tip in mind, all officers enter the residence and a search reveals cocaine. Did they mess up already? Yes or no? Tell me, did they mess up already just based on what I said? Yes or no? Did they? Don't be afraid. Yes or no? You type in the chat, I'll see it. Okay, I don't know what your answer is, but I'm not going to tell you what I think. And so, uh, and so keep in mind that all officers enter the residence and search and reveals cocaine. Although it is well established that information obtained from anonymous tipsters is questionable, at best you believe you are on solid ground. Can this evidence be used against David? All right. Well, you learned about the procedural due process. We've talked about that already. When you have the right to discover, through the discovery process or disclosure process, as it's called in some jurisdiction, the evidence that is held by the prosecution and collected. And so all evidence must be legally obtained. The exclusionary rule will forbid illegally seized evidence from being used at the trial. I don't care how bad it appears. I don't care how bad you might feel it is. So what we're going to deal with the exclusionary rule and how this powerful rule serves as a check and balance between courts and law enforcement, the executive branch, that's law enforcement. So let's talk about where it came from. Again, I'm going to provide you with a summary of some information that I put together in a previous constitutional law class after this is over. So the good old Weeks versus the United States, going back to 1914. And we're going to discuss Mapp versus Ohio. All right. So let's take a look at Weeks first. So the Supreme Court first acknowledged that there was such a thing as exclusionary rule in the Weeks case. This Fremont Weeks, a Missouri resident, was suspected of illegally mailing coupons representing a lottery or gift enterprise, a violation of the criminal code. He was arrested without a warrant at his workplace. While the police officers had gone to his residence, a neighbor told police where a key was kept and was used to enter and search for the evidence. So various papers, books, property, money, notes, etc., were seized and turned over to the U.S. Marshal. Later the same day, the police returned to residence with the U.S. Marshal, conducted another warrantless search, and removed additional items. He was prosecuted in the federal court because the fraudulent lottery tickets were sent through the mail across state lines. Before trial, the defendant demanded his property be returned, but the court said no. He was convicted, fined, and imprisoned. At the United States Supreme Court case, in the landmark case, the justices looked at and examined if the search of his house violated the Fourth Amendment. Unreasonable search and seizure. Was it an unreasonable search and seizure? And if so, should the evidence be permitted at trial? Well, the court said very clearly the search was unlawful. The search was unlawful. And the seized evidence cannot, hear me, could not be used in trial against the defendant and should have been properly excluded. So the court applied the rule to the federal authorities because the U.S. Marshal had been part of the seizure. In contrast, the papers were not seized by the police under any claim of federal authority. Therefore, the exclusionary rule did not apply to state officers. Remember, I told you how that works. It would change. This would change, as I've told you later. All right. So Weeks tells us very clearly that you can't just go into somebody's place without obtaining a warrant. And you must follow the processes of obtaining a warrant. And one of the steps that's necessary is to take your tip, your belief, your suspicions to a judge or magistrate. And the judge or magistrate will hear the basis that you have for obtaining the search warrant or arrest warrant. And if it's an arrest warrant describing the particular location, the places, and things of that nature. If it's an arrest warrant, naming the individual in particular who it is you're seeking to arrest. And that must be supported by an affidavit that the judge will approve. Now, if the judge does not approve it and you search whatever evidence, I don't care what kind it is, how heinous it is, I'm tipping you off to something, it can't be used. So what does that mean? What I told you earlier about I'm preparing you to follow processes so that you can adequately receive credit for good grades, your assignments, preparing you for when you become a professional, that your work will be done in a professional manner, ethical as well. So Weeks versus United States stands for that proposition. All right, let's move on. The landmark case of Mapp versus Ohio involved the exclusionary rule, now applying it to the states. Okay, remember now, that was in 1914. Yeah. So now here we come 50 something years later. And finally, think about that. The gap in between that time, the exclusionary rule did not apply to the states. That's like a wow, to us. So Mapp versus Ohio applied the exclusionary rule now to the states. So a state case. And this was a very simple case. Miss Mapp was suspected of hiding a bomber inside her home, but arrested for possession of lewd and lascivious books, papers, pictures, and so forth. The police were not granted entry, and she called for her attorney, who made his way to the residence. The officers returned 3 hours later and forced entry into the house. That don't even sound like the United States, but that's what happened. Officers would not allow the defendant's attorney to enter the residence, barred the attorney. I mean, think about it. I mean, I'm setting you up to understand how even, no matter who you are, no matter what your politics position, you still got to follow the right processes. Officers would not allow the attorney, and she demanded to see a search warrant, which is something now that is standard. An officer held up an alleged search warrant, which she snatched from his hands and tried to conceal it on her body. The officer struggled, retrieved the warrant, and handcuffed her. The officers continued to search throughout the residence and located obscene materials in violation of Ohio law. The bomber was not found. So it wasn't about a bomber. All right. A lot of people thought that. But no, the police were unable to produce a warrant. You know why? Because that piece of paper wasn't a warrant. But she was still convicted anyway. On appeal, the state Supreme Court said there is in the record considerable doubt as to whether there ever was any warrant. However, the evidence was not taken directly from her by using brutal or offensive physical force. So it could be used against her at trial, the court said. That's what the Ohio Supreme Court said, the state Supreme Court. And they believed that based on Wolf versus Colorado, a 49 case, permitted the admissibility of the evidence at trial, even if it was seized unlawfully. Wow. So you could violate the law as a law enforcement officer. That's an oxymoron. All right. In Wolf versus Colorado, just to give you a little bit about that, the 49 case, the Supreme Court said that if states were required to exclude illegally seized evidence from trial under the 14th Amendment search and seizure and the 4th Amendment due process clause, the court said the exclusion of the evidence may have an effective way to deter unreasonable searches. Other methods could be equally effective, such as civil remedies, internal police discipline, and the watchful eye of the public. In other words, what they were saying is, nah, this might be bad, but it's not that bad. That's pretty much what they said. That's pretty much what they said. Let me see what you said. I can get that. Give me a second. Um, oh, okay. Okay. Oh, you said yes to earlier. Okay. Yeah, I don't know what's going on because it's it's pretty strong here. Um, let's see. I want to make sure that, yeah, the volume is working. My mic is working. Internet's working. Speakers up to 100%. We are recording. So I don't know. It's a technical issue that you're having. So okay. So anyway, the point of the matter is that she was convicted by the state court and lost appeal. So she went all the way to the United States Supreme Court, which granted certiorari. Now, just for your own information, certiorari means that they agreed to hear the case. Supreme Court doesn't have to hear every case, and if they grant certiorari, that means that they want to hear it. That doesn't mean that they agree with the decision or disagree. But look at what happened. This hardly ever happens. In a unanimous decision, the Supreme Court agreed with the defendant that her Fourth Amendment prohibiting unreasonable search and seizures were violated. Therefore, the evidence should not be used against her at trial. The case was reversed and remanded back to the state court. What that meant is that the case was reversed. The Dolary map case applied the exclusionary rule to the states for the first time, as I said, and has been applied many times since that to exclude unlawfully seized evidence from being used against defendants. As we talk about the infamous Miranda versus Arizona case, 1967. I don't think it was a 67 case. I think it was 66. But anyway, the case applied the exclusionary rule to improperly obtain confessions. And that's when we came up with the right to the Miranda warnings before you're questioned while you're in custody. So the exclusionary rule also helps prevent law enforcement officers from being, as I said earlier, lawbreakers. And that law enforcement should be leading by example. If enforcement breaks the law, it can create distrust. So anyway, then we came up with the what we call the fruit of poisonous tree doctrine, which goes right with that. So the exclusionary rule prevents any evidence that was not seized properly from being used at trial. And so the effect of that is what we call the fruit of the poisonous tree doctrine. The deal is that the evidence, if it was illegally seized, the tree or the power that gave them to get that evidence is to be made poisonous to the case and to the constitutional rights of the individual. And so this doctrine, established in 1920 in the Silverthorne case, was obtained pursuant to an unconstitutional search and seizure. So any evidence obtained from the unconstitutional search or seizure cannot or should not be introduced in court. It would be a mistrial. Okay? The rule extends to any fruit of a crime obtained from unlawful seizure or search or interrogation, and it cannot be used. So if a police officer violates the Fifth Amendment rights to remain silent or the Sixth right to an attorney during a custodial hearing, any statements made during the interrogation cannot be used because it derives from the fruit the constitutional violation. Now, based on what you've learned in so far, revisit David. You don't have to speak out to me, but revisit David and the situation and determine what do you think would be the outcome. Well, you're going to demonstrate that in your writings. All right. The exclusionary rule is, as it says, is powerful and serves as a check and balance. And there are a few exceptions. So we're going to talk about a few of those exceptions. And once again, I will provide you with some information there. Incidentally, here are the full citations for these cases. Mapp versus Ohio, Miranda versus Arizona. I thought it was a 66 case. Yeah, it was a 66, not 67. Silverthorne Lumber versus U.S. Here's their citation. And then, of course, Weeks. Okay. All right. Okay. So now that's it for the all important exclusionary rule. Okay. Are you good now, Mindy? If so, let me know. Yes. Sorry that you're having those issues, but I don't see any issues on this end. Okay, good. Whatever you felt, that's why I tell people you can go back and hear the recording as well. So now let's talk about the exceptions. We already covered very well what the exclusionary rule is all about. So here's a little bit of information. Again, I will provide you with more as soon as this session is over. So it gives you a hypothetical. You are a dedicated and proactive police officer in your community. In your downtime, you often try to find wanted subjects. One day, while searching through your warrant database, you locate one for a man known to you from prior contact as John Smith, date of birth, January 1st, 95. With your knowledge of the warrant and another officer, you travel to John's house and contact him at the front door. Upon telling him he is under arrest, John insists this is a mistake. Okay, although John is upset, he does not resist and is handcuffed without incident. Upon searching John, you find a small bundle of suspected methamphetamine, which tests positive with a field test kit. Just before the transport to the jail, you realize there was a mistake. Oops. January 1st, January 10th, 95, and not January 1st, 95. You looked into it further and discovered you made a mistake. Ew. Ouch. Oops. A prosecution's nightmare and a defense attorney's, as we say in church, hallelujah. Or, oh, wow. Okay. The way that Venus and Serena Williams serve in tennis, they have what they call aces. You all have heard those. And what that means is you hit the ball over and the other side is not even able to reply back or hit back. So an ace is scored. And with appropriate motion, the case will be done. Can the seize evidence pursuant to a mistaken belief a warrant had been issued be used against John in court? Well, the answer is no. That's it. But anyway, you look at these references and you'll see what I'm talking about. So again, we're going to get more into exceptions for you because there are some exceptions to the exclusionary rule. In other words, the police have what we call a mulligan or something that they can use. All right, so I think this section is the one that kind of covers a little bit. Okay. Okay, so you can't hear what she's saying, but be aware that there are 4 exceptions here. And again, I will provide you with more information. So let's so I'm going to look at the good faith exception first. Here. Now, I remained silent while you could have read that. But one of the key things to remember is that with the good faith exception is that it gives the law enforcement officer the opportunity to be able to, if, as it says, one of the key things, if they were acting in good faith in compliance with the Constitution and performing their duties, then even though it would be unlawfully obtained under the exclusionary rule, this exception allows it um, to go forth. We as defense lawyers fight that all the time because we argue quite vehemently what good faith means, and there's been a lot of cases that have provided it. But just for now, I want you to be aware of that. All right, let's go to the next exception, and that's the independent source doctrine. Pay attention to what's said, and then listen to my comments. Okay, so anyway, I'm gonna not go with the next ones, but just be aware that there are these exceptions, and I will provide this. But this exception says that it could have been discovered by other means, by a preponderance of the evidence. Okay, so um, we're going to skip over these two and then next here. That's the end of it, actually. All right, so I'm going to send you more information, okay? A knowledge check that you can do after is to go over this, and you can begin and deal with these questions and ask the right to pass freely from state to state, to petition Congress for redress of grievances, and the right to vote are examples of what? Is it the Fifth Amendment right, procedural, substantive due process rights, privileges and immunities? How about this one? Let's submit it. Yep. So you can go through each of these and you come up with that. Okay. Well, that's it for today. And if you have been listening to this lecture, then you totally should know what the key phrase is. How about the exclusionary rule? Give me exclusionary rule and you get your points. All right, it's just a couple minutes over, but I wanted to go over that with you. If you have any questions, feel free to reach out to me. You know the way. I will see you next week. Stay safe. Take care of yourself. Get those assignments in. Good night.